is disabled, so we can get a feedback.
Okay.
Yeah, she's here.
Hi, Peggy.
Good morning, Katie. There, okay. Okay, I have 12 o'clock straight up, so let's get started. Good afternoon, everyone, and here we are, March 15th. We are springing forward. Hard to believe we're already into March. Seems like yesterday was the holidays. I want to welcome all of the guests today to our presentation called To Fine or Not to Fine. I am Peggy West. I'm your organizer. And I want to thank the board members and the property managers on today because knowledge is power. And I commend all of you for continuing your education and your information on the Florida laws. CAMS today, you will receive 1 hour credit for this course. You must stay on the call, at least 75% of the call. And we are recording. I want to also thank all who invited you as guests. That would be my sponsors. I just mentioned we have over 600 registered for this course today. And here are today's sponsors. I'll start with myself. I'm actually working also with Beach and Patio Outdoor Living. We just rebranded effective Monday this week. We were Sun and Beach Patio Furniture. So Beach and Patio Outdoor Living, it's a Condo deck and homeowner association pool decks. We do everything, repairs included. I can get you beautiful cabanas, chase lounges, and so on. With that, I'm going to move on to the wind beneath my wings. That would be Layla. Layla, wave at everybody. There she is, IT expert, and she is also the head of customer success and marketing for Vinteum software. I'm going to let you say a few words, Layla, and also I want to make an honorable mention about another partner with her is Jasmine Johannes. She is also the marketing director.
Thank you so much, Peggy. Hi, my name's Layla. I work here at Vinteum. We are a software company. We provide websites and portals for HOAs and condos across North America. So to have an online presence to improve your communication and management, do get a website and do get in touch with us.
Excellent. They have so many services, emergency services, package delivery services, calendar services. If you don't have a website, you've got to talk to them because the number one thing is they have affordable services, right? Next, I just want to mention Nicole Johnson. She is not on today. She is in the thrust, and today is this big day for taxes. She's with Hafer Company, CPA Services. Nicole is the partner and also an operations manager. They are full service, and if you need a good CPA, you need to call Hafer. Next, I want to introduce Erin Nickerson. She's the Director of Business Development from Rapid Response Team. Erin, tell us about yourself and the company, please, and wave.
Good morning, everyone. My name is Erin Nickerson with the Rapid Response Team. We are a licensed general contractor that specializes in the emergency services world. Long story short, if it's on the interior of your building and does not belong there, we can fix it and rebuild you. We're also, reminder, getting into hurricane season, so it's time to start your planning as property managers and boards of directors. If you need any assistance with the planning process, please feel free to call or email me directly, and I can help work through that with you. Enjoy the class.
Thank you so much. Okay, next I want to introduce Michael York. He is the Director of Business Development for Socotec. Mike, tell us about yourself and the company.
Yes, good morning, and thank you to everyone for attending and all the other sponsors. Erin, you gave me chills when you mentioned hurricane season fast approaching, because we're just starting to deal with, yep, we're just still dealing with Nicole and Ian. But as mentioned, my name is Michael York. I'm a director with Socotec Consulting. We're a full service engineering firm that specializes in the condominium and association world. And we are able to help with anything from 558 litigation claims insurance claims, to turnover reserve studies, and everything in between, painting, concrete restoration, roofing, waterproofing, etc. So sort of a one-stop shop for you. We can put proposals out in less than 2 weeks and have boots on ground within 2 weeks as well. So if we can be of service, please feel free to reach out. And thank you all for having us this morning.
Awesome. That's awesome. 2 weeks. That's awesome. Okay, next I want to move to introducing Erica D'Alessandro. She's with Nuvo, Florida. Erica, tell us about your company, your business, and also yourself.
Good afternoon, everyone. My name is
Yes,
Erica
yes.
D'Alessandro, and I'm the Business Development Manager here at Nuvo, Florida. We are a full-service elevator contractor. We handle all of your vertical needs, whether it be elevators, escalators, or moving walks. We currently service between Florida, New York, New Jersey. We have 13 locations. We've been in business 35 years. There is a new elevator code that is being required by the state of Florida with the deadline of December 31st, 2023, called door lock monitoring. If you have any questions or concerns regarding the new regulation, please feel free to reach out. And once again, like Erin mentioned before, hurricane season, most managers don't know how to put the elevator in service or take the elevator out of service when it comes to hurricane season, prior to the hurricane season, during the hurricane, and after the hurricane. So if you have any questions or concerns, please feel free to reach out.
Awesome. There's a lot of elevators out there too, I know for sure. Okay, next I want to introduce a longtime contact and friend of mine in the business, Kathy Dorn. She's a Vice President for Customer Relations at South State Bank. Kathy, tell us about yourself and the bank, please.
All right, thank you, Peggy. Hi, everyone, and thank you for attending. My name is Kathy Dorn, and I am an association relationship manager with South State Bank. Our company, South State Bank, has been serving associations for more than 20 years. We offer a full suite of services that deal with lockbox cash management, deposit services. In light of what's happening in the industry today, we've seen a lot of news about banks. I'm sure associations are concerned about insuring their deposits for more than $250,000. There are products for that, insured cash sweep accounts, as well as CDARs, where an association can keep all of their funds in one depository institution and still insure it for more than $250,000. We also offer lines of credit, which may come in very handy since everyone's talking about hurricane season. And so if you have any questions, I'm happy to speak with anyone. Again, thank you for attending today. My name is Kathy Dorn with South State Bank.
Thanks, Kathy, and thank you for sponsoring today. Next, I want to introduce Sergio Roncasio from Sherwin-Williams. And if you have anybody on your team also, you can introduce them. Sergio, tell us about yourself. I know you have a lot on your plate. I think you mentioned 30 people working for you underneath you, and also what area you cover.
Yes, good afternoon, everybody. Thank you, Peggy, for putting this together, for having us here. My name is Sergio Roncasio. I work for Sherwin-Williams. I'm the trusted advisor for everything in Miami-Dade County that comes to projects like exterior repaints, interior renovations. My coworker Jessica Ocasio does the same in Broward County, and then we have Jill doing exactly the same for the Palm Beach County. So anytime you have a project coming up, if you need a budget for the project, if you need painting contractors, or if you need the engineers to oversee your project, you can reach out to us and we'll be able to help you from the very beginning until the warranty request.
Okay, awesome. And is this Jessica?
Yeah, I'm here.
Your team? Yes.
Thank you for having me.
Can you tell us about yourself? Yes.
Thank you. I've been working for Sherwin-Williams for 4 years. I'm one of the trusted advisors. You can contact us, as Sergio says, for any specification. You can call for color renderings, anything you need for painting, supplies and contractors. We can help you to do the process, and you don't have to start going different vendors just to get all the projects done.
Okay, great. All right. Next, I want to introduce Chris Clark. He's the marketing manager for Munyon Painting. He is not on the call today, but he has been a sponsor for a long time, a couple years now. He is knee deep still in Fort Myers, speaking of hurricanes. So we're continuing into the new year with lots of projects he's still working on. But Munyon Painting is a user of Sherwin-Williams products. And if you need anything, his name will be on the sponsor sheet. Now I want to introduce Katie Phillips. She's the education director for Rosenbaum PLLC, and she will be introducing our speaker. But Katie, first, will you please tell us about yourself? You've been in the industry a long time and longtime friend. So tell us about yourself and what you do for Rosenbaum.
Thanks, Peggy. And I'm here with Steve. I'm not Steve, but I'm here with Steve because we're in the same room, so I don't want to get feedback. But I am also on the webinar, and I'll be able to help answer some of the questions. If you guys please use the Q&A instead of the chat once we get started. We monitor the Q&A once the presentation starts. But Rosenbaum PLLC. So we are a full service law firm with offices in West Palm Beach and in Stewart. We handle everything in-house from your collections, your litigation, your general legal matters, contract review, which is a huge thing these days, and document amendments, and of course fines, which Steve is going to talk about today. I'm the education director here at the firm. I've been in this industry now going on 26 years. I was previously a regional director for a large management company overseeing way too many properties in 3 counties. And I really love my job here at the firm. And we provide all the classes, the print and social media. A lot of you are on my mailing list. A lot of you are on Peggy's mailing list, but we do a lot of classes, a lot of events, and try to make legal a fun thing because nobody really likes legal, right? And Steve,
you do a great job, by the way.
Thank you. I appreciate it. Steve Braten is the shareholder here in charge of our association department. I'll let him actually say a few words about himself before we get started, but just a few little housekeeping things. I did put it in the chat. I use a third-party provider for your certificates, and we import that information from Zoom. So if you do not see your certificate by Friday, please check your spam folder. A lot of times it does get routed there. It is a link in an email for you to click and download your certificate. They are digital certificates, and we will get those out to you this week. You should have them by Friday. For the CAM managers, and there's a lot of them on here today, please give me 5 to 7 business days for the DBPR. We're utilizing their new upload instead of manually entering everybody's information. And it's been taking 5 to 7 business days for them to actually register your credit. So please give me a week or so before you tell me it's not there. Just, give it a little bit of time, but I promise you, I usually get the confirmation Friday when I will upload everything, but it's taking them 5 to 7 business days. And with that, I'm going to go ahead and share the screen, let Steve tell you a little bit about himself, and then we can go ahead and get started. 1 second.
Thank you, Katie.
Thanks, Peggy. You want this hidden?
Yeah.
Okay,
Okay. Perfect.
there you go.
Thanks.
No problem.
All right. Good afternoon, everybody. Thank you for, first I want to thank the sponsors for making today's class possible and all the things that you all do to help support our association clients. So we greatly appreciate that. And thank you all for attending the webinar today. And hopefully we'll be able to provide you some useful information about fines. So to fine or not to fine, that is the question that preoccupies our boards and managers alike. And so we're going to talk about the the requirements for imposing a valid fine, and also the pros and cons and the various different things that you can do in addition to monetary fines that may help you either stop certain behavior that we want an owner or a member to stop, or to encourage certain behavior that the person is refusing to engage in. So let's get started here. All right. So covenant enforcement, we're going to cover both condos and HOAs today. The statutes are a bit different, and we will discuss the significant differences between the two. But as a threshold matter, it's very important that your association enforce uniformly its restrictions and rules and regulations. And, just by way of a little background, just, as a step back, when we talk about what we're enforcing in terms of violations, we look at our declaration, whether it's our declaration of condominium or declaration of covenants and restrictions, for what use restrictions govern the community. And then we also turn to our rules and regulations, which are adopted by the board, in terms of, how those rules complement the declaration and work together towards, managing the community in hopefully a harmonious manner. Right. So enforcement is a critical part to, the use restrictions having any meaning if we don't uniformly and consistently enforce our use restrictions, and we allow violations to occur without any repercussions, we can compromise our ability to enforce those restrictions, including in a court of law if it gets to that point. Okay. So in that regard, enforcement should begin as soon as possible. We need to have a process in place whereby, depending on the size of your community, who is going to identify and inspect the community for potential violations. So, for example, if you're a high-rise condominium, that process may look very different than if you're a low-rise condominium or homeowners association, where you have, a spread out, units are spread out. You may have to have more frequent inspections of the community versus in the building, where it may be easier in a confined area to identify violations. Okay. Once we observe a violation, we do need to take quick action. We don't want to let a violation linger. We want to address it immediately, as soon as possible. And typically we're going to do that with an initial notice, which, oftentimes is what I like to call a friendly reminder. We're going to assume the person may have forgotten the restriction. Maybe, they're a guest, whoever, whatever the case may be. We start off with an initial warning that's kind of a friendly reminder, right? Now, once we've done that process and we're looking at, okay, the friendly reminder, maybe another follow-up warning letter that's a little stronger isn't working, and we're actually going to consider levying a fine, we need to, look at our governing documents to make sure we have the authority to do that. Typically, the association can rely on the statute, so long as there isn't any language in your governing documents that prohibit or modify the process for levying fines. And what I mean by that is the statutes, as we get into, will set certain dollar amounts, and your documents may either have language that limit the amount of the fine you can impose below the statutory threshold. So these are things you need to look at and consult legal counsel about. Okay. But I think most important is have a process in place that everybody understands. I like to have our clients adopt what I call a covenant enforcement policy that lays out the entire policy, including what notices the owners can expect to receive either from the board or management, so that they understand what the process is and what they can expect if they don't if they don't adhere to the rules, regulations, and restrictions. All right. Now, the as we note here, it's critical to follow the statutory process for imposing fines. And when I talk about fines, I also want to mention suspensions as well. So both condominium and HOA statute permit, in addition to fines, suspension of use rights. So when we're talking about fines, we're also talking potentially about the suspension of certain use rights. And I'm just going to refer to that generically as fines. So if we end up in court trying to enforce a fine, the first place opposing counsel is going to go is try to challenge the process that was followed by the association. The law in Florida is that the fining statutes are to be strictly construed, meaning if you don't follow the statute to the letter, chances are the fine is not going to be held up by a judge. So it's very important to follow that statutory process. Okay. Selective enforcement, which I alluded to earlier, is if we have a scenario where the association isn't uniformly and consistently enforcing its use restrictions and rules. We know about violations, we're not doing anything about them, and then suddenly we decide we're going to go after some particular owner. That's going to be a problem. That owner, depending on the nature of the violation, can point to, for example, in a homeowners association where we're talking about architectural changes to the home. If other owners have done it and we're singling out somebody else, that's going to be a problem. Okay, so if you're in a situation where as a board and you're new to your board and you're looking at past enforcement and has not been consistent, then I recommend that you reach out to your association counsel for what steps you can take to essentially revive those restrictions that were not being uniformly enforced, how we identify problems in the community or in the building that we're going to say, okay, we can't do anything about those, but moving forward, we're not going to allow that to happen again. There's a process under the law you can go through to republish your restrictions and essentially grandfather in perhaps certain modifications that were made that shouldn't have been made. And so again, consult counsel on how to go about that process, right? So when we talk about specific covenants and restrictions, the board is responsible to enforce. Depending on your community, we're talking about architectural standards and alterations, pet restrictions, restrictions on leasing and sales, parking and vehicle restrictions, and then something a little bit more generic is nuisance and noise complaints. And that can cover a variety of different issues, including, for example, we've gotten smoking complaints, not just noise complaints, and other things that may, constitute a nuisance, including, for example, harassing behavior by an owner that can fall into that category as well. Now, every owner, tenant, and other invitee, including guests, are governed by the Florida statutes for condominiums and homeowners associations, the community's declaration, its articles of incorporation, which created the association, its bylaws, and its rules and regulations. And the statutory sections are there for your reference.
We have some co-op members on here today, so can you just clarify if that
Sure.
is also covered by co-op?
Absolutely. So you have to refer back to the co-op statute under 719. And that statute is going to look a lot like 718 303. Okay. Now, in order to have a fining process in place, you must have a fining committee. Okay. And that fining committee can only consist of certain people in the community. Right. So let's talk about, and the committee goes by different names, but at the end of the day, it's the same thing. Whether you call it a violation committee, suspension committee, etc., that committee is intended to ultimately approve or reject a fine that's been levied by the board. And one of the things that we're going to emphasize today, which is critically important, is that when you're imposing fines or suspensions, it's a two-step process. Okay, and this is where this process typically breaks down, and we'll get into that in detail here. All right, so we talked about not wanting to wait until, well, certainly we want to have a committee in place before we're going to go down the process of fining. You don't want to wait until you have violations before you create that committee, because that's going to take too long, and those violations are going to be outstanding for too long a period of time. So it's important that everybody has access to all the restrictions and rules and regulations. If you have a website, those should be posted on your community website or available, in your office for owners to have. Okay. If you establish any new rules or restrictions or amendments, those should be published to the community as soon as those are either adopted by the board or approved by the membership. You're not going to be able to successfully levy a fine unless the owners are on notice of what it is you're trying to enforce. Okay. Also, you have to evaluate whether the type of violation is appropriate for a fine. if it's a one-off isolated incident, that may not be necessarily the appropriate way to handle it. You need to look at what the behavior is, whether it's recurring, before you may want to consider, imposing a fine or any type of suspension. Okay. If, something becomes more of a widespread problem, then you may want to consider fining. And then also, if the behavior that's being engaged in, such as harassing behavior, it may not fall squarely into your nuisance provision in your documents, then what we recommend to our clients to do is adopt what we call a civility policy, or a non-interference policy, to make sure that owners understand that, hey, as directors, we're volunteers. Also, our managers who we pay need to be able to focus on managing the community, not dealing with, harassing emails or berating emails or bullying emails or any other types of communications. So we want to implement a policy like that, which the board can do typically based on the rulemaking authority in your governing documents. Okay.
Steve, can you just define harassment a little bit more?
Yeah. Well, harassment, there's actually a statutory definition. I don't have it off the top of my head. But anything that's, I would consider, whether it's aggressive, if we're talking about at a board meeting, for example, aggressive behavior, any threats that may be made to somebody, bullying, name calling, any of those types of things that, is considered unacceptable in the forum. I mean, certainly vulgarity in email communications, which I have seen directed at board members and managers. Those are the types of communications which, if they recur more than once, can constitute harassment. Okay. So if you're not sure whether or not the behavior in question falls into that category, then you certainly should reach out to your association counsel and get some guidance. And then, of course, if the behavior is very extreme, we always counsel our clients to don't hesitate to call the police. Okay. One of the things owners and members forget is that the association is not the police. If you're in fear of your safety, you need to call 911 first, not the association first. And I know that's a problem that our managers run into, where they get the phone call first and then I get the phone call second. And my response is, well, I think they need to call the police. So, make sure that that's clear to your members when we run into situations like that. We already talked briefly about, figuring out how long a violation has existed, whether or not you have an issue with enforcement, and, seeking out counsel to reestablish your ability to enforce rules that may have gone unenforced for a period of time by prior boards. Okay. For homeowners associations, 720-3052 contains the authority to levy fines against owners, tenants. Interesting, the word guest appears in 720. It doesn't appear in 718. Not sure if that was just an oversight by the legislature, but I think a guest falls into the same category as invitee. The previous statute only allowed HOAs to fine if the authority was in their governing documents. The statute was amended to now provide that your governing documents don't need to provide that authority. But again, I would check your documents to make sure there isn't any language in there that impacts how much of a fine you can levy for a violation, because I have seen in documents dollar amounts actually stated in older documents and bylaws or in the declaration. So it's important to make sure that if you're going to go down the fining path, that there's nothing in your documents that's going to limit your ability to do so or how you do so. Okay. So here we're talking about HOAs, but it's also the case for condominiums. Fines may not exceed, and co-ops may not exceed $100 per violation. Now, unlike in condo and co-op land, for HOAs, if your governing documents authorize a higher fine per violation or a higher per maximum fine, which under the statutes are $1,000 for a continuing violation. I've seen documents that in HOA land where it says you can have a fine for up to $500 per violation, maximum $5,000. So for homeowners associations, you can increase that statutory threshold, but it has to be done by an amendment to your documents if that wasn't put in there originally by the developer. Okay. And again, a fine may be levied for each day that there is a continuing violation. So an example of that would be if someone isn't maintaining their landscaping, you've gone through the process correctly, you've notified them, and they're not correcting the situation that you've specifically identified needs to be corrected. And again, specifically identified. So if it's, a dead tree, we want to identify, the dead tree. If we're talking about, failure to mow the grass, we want to give the person sufficient notice, which, a court is going to look at as, did this person get notice, which is part of, the due process requirements in the statute. The next part we're going to talk about as we go through here is the opportunity to be heard, and that's going to be before the fining committee. Okay. We talked about the maximum for a continuing violation. Sometimes we get into, what constitutes a violation and how many different violations can we assess against an owner. One of the things we don't want to do is get carried away with the fining process. The fining process is designed to compel, as I said before, certain behavior that the owner is refusing to engage in, or stop certain behavior they shouldn't be engaging in. And if the fining process isn't working, then we need to turn to the legal process. This is not, at least from my perspective, a revenue generator for the association. That's not what the intent of the fining statutes were about. Okay. Now, for homeowners associations, once your fine reaches a level of $1,000, you do have a right to lien a parcel for the fines. And for condominiums and co-ops, you cannot lien the unit for fines. So that's a significant limitation for condominiums and co-ops versus homeowners associations. I have no basis for the rationale for that. That's just the way the legislature set that up. Perhaps the thought process is there's a lot more fining that goes on in condominiums and co-ops, and they don't want it to turn into a lien foreclosure action.
So Steve, really quickly, on the exceeding the statutory limits of $1,000, they have to have that language in their documents, correct?
Right. So in order and this is for HOAs only, I want to be real clear about that. For a homeowners association, in order to exceed the statutory limits, which is up to $100 of fine per violation, not per fine, per violation, and maximum $1,000, to exceed those two thresholds, it has to be in the declaration of restrictions, and that would require a vote of your owners. Okay. Otherwise, you have to go with the statutory limits. Okay. So when we talk about condominium associations here, the authority to fine comes from 718-303. Again, here it does not have to be in your governing documents, but I come back to always checking your documents to make sure there isn't anything in there that would create a problem. We talked about the fact that condos may not lien a unit for fines, and we have that $100 per violation, 1,000 aggregate, and that cannot be changed. Okay. So let's talk about the role of the fining committee a bit. But before we do that, I wanted to talk about the board's role in the process. So when you look at 718, 719, and 720, I mentioned that there's a two-step process. And what the statutes say is the board must first levy a fine. Okay. And then what does the committee do? Well, the role of the fining committee is to either accept or reject the fine levied by the board. So on the front end, the board has a couple of things it has to do. First, it has to determine how much of a fine they're going to levy for a particular violation, because it's not necessarily automatically $100. It could be $25 for a first time infraction, or $50, or whatever the board decides is reasonable. Those are the words in the statute. what's reasonable for the violation. So what I recommend to our clients is that they come up with a schedule of common violations that they see occur in the community and put them into two categories, and that is minor infractions and major infractions. And then come up with an amount that makes sense for the minor infractions and then for the major infractions, where the major infractions tend to be on the $100 threshold out of the box, and perhaps on the minor infractions, you start out with a lower number. And then, of course, you can work in suspensions into the mix for both minor and major violations. A suspension can be levied in addition to a fine, so they can occur contemporaneously. It's not like it's one or the other. Okay, depending on your community, suspension of use rights may not be an option. If you can't restrict people's access to a clubhouse or the use of the pool or the use of the fitness room, based on however you're configured. Some communities have fobs that can be just shut off, using software. That makes it simple to suspend use rights. Whereas if you have unfettered access to some of these facilities, it may not be possible to engage in effective suspension. If you have a manned gate and owners have an RFID sticker on their window that allows them to go through the owner lane, suspension can become very effective there, because you can force them to go through the guest lane, have to show their identification to get into their own community. We find that to be very effective when it comes to collecting fines. So just some thoughts there. But once we get into what is the role of the fining committee, again, it's strictly limited to determining whether to confirm or reject the fine levied by the board. So the board at this point has already decided the amount of the fine, has held a board meeting, duly noticed board meeting, and voted on the fine. Okay. Once that occurs, we then need to send out a written notice to the owner of their opportunity to appear before the fining committee to be heard. So that's the other part of the notice was what was the violation, and then the opportunity to be heard is going to be before the fining committee, not necessarily before the board, but rather at the fining committee level. The committee, if the committee doesn't approve the fine exactly as levied by the board, it cannot be imposed. And this was a change to the statute that was done a few years back. So whereas the committee used to have the discretion to say, okay, we're going to reduce the fine to X. Well, the committee can't do that. If the board levied $1,000 fine based on a continuing violation, the committee either needs to approve that or reject that. If the committee rejects it, that's the end of the process. No fine is levied, and the board would have to start over with the enforcement process if there was a future violation. Now, presumably the committee, if they're rejecting a fine, it's because they've been presented evidence by the owner that perhaps the fine never should have been levied in the first place, or they had some mitigating factors that the committee took into consideration, and the violation was cured by the time it got to the committee. If the committee is not performing its role because it doesn't want to be the bad guy, then we have the wrong people on the committee. Okay, because the committee has to be willing to approve fines when it's appropriate.
Let's talk about that real quick, Steve. So who can actually be on this committee?
Right. So who can be on the committee? It's probably the next slide, right? Here we go. Can't be members of the board. It cannot be the officers, directors, employees of the association, or any spouse, parent, child, sibling of an officer, director, or employee of the association. So these folks have to be completely disinterested members of the association that have no connection to the board members, employees, or management.
Right. And so if they can't get multiple different unit owners from different units, but they do have like a husband and wife that are not on the board, is that permitted?
Yeah, that would be okay.
Okay.
Yeah, yes. So the question was, if I have a husband and wife who own one unit and both of them are on the committee, but they don't fall into one of these restrictions, can they serve on the committee? The answer is yes. I mean, obviously, if that should be a last resort. But the statute doesn't preclude it. Now, you have to have at least 3 members to have a valid committee. And the reason for that is the statutes specifically require that a majority of the committee approve or reject the fine. So in order for a fine to be properly approved, the committee has to vote, and it has to be passed by a majority. One of the things that I recommend to our clients is the minimum requirement is 3. If you can get 5, that's fabulous. And then what you can do, because, people tend not to want to, they're concerned about how much time they're going to have to commit to this process. If you have 5 members, you can do a rolling 3 at your committee meetings, because a quorum of the committee would be 3, and then a majority would be 2 out of 3. Not all 5 members would have to appear. Now, if you get 4 people that show up, that could be a problem. So just watch out for that. All right. And then there was something else I wanted to mention about the, just slipped my mind. So we talked about who the committee must consist of. We've talked about the limits on the authority of the committee. And if the committee does not approve the fine, then the fine cannot be imposed. All right. Now, once the committee, a couple things I want to note about the committees, and this is a little different for condos and co-ops versus homeowners associations. So under chapter 720, when we talk about holding committees in general, committee meetings in general, the only 2 committees that have to conduct themselves the same way that the board does, which means, noticing the meeting and having members be able to attend those meetings, is your architectural review committee, which is a standing committee for HOAs. And then if you have delegated any authority to a committee to make decisions on behalf of the board, such as spending decisions or adopt the budget of the association. So those 2 types of committees must be noticed 48 hours in advance. Members have to have an opportunity to attend and speak at those meetings. The fining committee doesn't fall into that category, and therefore they're exempt from the notice and notice requirements, and for members to be able to attend those meetings. Condo and co-op, that's not the default. The default is, unless your bylaws exempt the fining committee, you're required to notice those meetings and let members attend those meetings. So that can become a bit uncomfortable. So if your bylaw, I recommend to condos and co-ops, get with your association attorney, take a look at what committees have to follow the notice requirements of 718 and 719. And that's something you may want to amend so that you can hold these fining committee meetings without, the general membership being able to attend those meetings. Either way, minutes of those meetings should be kept. And the minutes should reflect each unit or each property that was brought before the committee, what the issues were, whether the member showed up, to present their side of the case. Oftentimes, nobody shows up at the committee. I wanted to dispel a misconception about that right there. The owner does not have to request an opportunity to appear before the committee in order for the committee to meet. The statutes are very specific that the owner must be provided at least 14 days notice of the committee meeting. That notice should be sent by certified mail, return receipt requested, and I would send it also regular mail. And I would set your meeting date out an extra 5 days, or unless you designate the same day every month. We have communities that are larger communities, and the committee meets on the X day of the month every month. And if you can't get that notice out prior to the next committee meeting, you need to roll it to the following month. But I like to go by 19 days. So you allow for 5 days for mail in terms of setting the date of the meeting. Your notice has to give the date, time, and place that the meeting is going to be conducted. Okay. There's no requirement that the member be allowed to attend a fining committee by Zoom. If you want to do it that way, that's an option, but there's no requirement in the statutes that you have to do it that way.
So
Question?
Steve, yeah. So for the actual fines to go to the fines committee meeting, there's several questions in here about, does the board need to approve it first?
Right. So the questions are, does the board need to approve the fine or suspension first before it goes to the fining committee? And the general answer to that question is yes. The only potential exception to this, and this hasn't been, tested, and there's no court decision on it, is whether or not the board adopts by resolution certain violations and assigns a fine or suspension period to it, and therefore doesn't have to necessarily meet each time to address a violation. The statute says the board, has to levy the fine. So again, can it be done through a resolution so the board doesn't have to meet every time, to avoid getting bogged down in, the business of the board becomes, fines as opposed to the normal business of the board. Again, reach out to your association counsel, discuss that possibility with them, but there has to be that first step of board action before you get to the fining committee. If your board can't agree on that a violation has actually occurred, or can't agree on how much of a fine to levy, then you're stuck and you can't move forward. Now, one thing everybody needs to keep in mind is, fining is not the only option when we're dealing with violations. It's just one option, and it tends to be a less expensive option than, getting legal counsel involved and going through, the arbitration or court system in order to enforce your restrictions and rules. However, you may end up having to do that anyway, depending on what the outcome is with the violation process or with the fining process, or the situation may be so severe that the board decides, this is something that we need to escalate sooner than later, and we're going to bypass the fining process and go straight to the legal process. That's for the board to decide. Okay. Any other questions?
There's tons, but
okay.
All
right,
I'm
no
going to cover as many as I can as we go through, and then we'll answer at the end specific.
So, so again, want to emphasize it's important to have a covenant enforcement policy in place, which as part of that policy identifies who's going to bring violations to the attention of the association, and also who's going to conduct routine inspections of the property to ascertain if there are violations. And, the people who can bring these things to the attention of the board, obviously, is management, any owner, and any member of the board. Okay. Now, when we get a complaint about behavior or conduct, my recommendation is we get that complaint from the complaining party in writing. If the person is not willing to put it in writing, then that's a problem, because we're not then ultimately that person really isn't going to be a cooperative witness, and you're going to have a hard time proving your case. And that's an important part I want to also address. When you go in front of the fining committee, it's like a mini hearing. Okay, the rules of evidence and all the courtroom procedures don't necessarily apply, but somebody needs to be representing the association at the committee hearing, presenting the fine, or presenting the violation to the committee. And then the owner has the opportunity to present their side of their case and any evidence that they want the committee to consider. Now, if we have a process in place for the fining and suspension process, one of the things we can do is specify that any documents or any evidence, written evidence, that the owner is going to want the committee to take into consideration, that it be submitted within a reasonable time before the actual fining committee hearing, so that walking into the hearing, the committee isn't seeing this for the first time, to have an opportunity to review it. I like to put in my policies that if the owner is going to be represented by legal counsel, the owner has to notify the association within a certain amount of time prior to the hearing, because the association then may want their legal counsel present at the fining committee meeting. And I've had that happen. Owner has a right to be represented by counsel at a fining committee hearing, because there's legal ramifications to the fine being levied. Okay. Going back to the enforcement process, which again should all be laid out in some type of policy, is information that is gathered is then reviewed. The board has to determine whether or not the conduct is meritorious of a violation. A violation notice should be sent out to the owner, tenant, guest. Typically, if it's a guest, it should go to the owner or tenant. If it's a tenant, it should also go to the owner. At the end of the day, the owner is ultimately responsible for anybody's conduct that is occupying their property, whether it's a condominium, co-op, or home and a homeowners association. We talked about, if it's the type of thing that's a one-off and whether, it's appropriate for fine, we send out the initial notice, give them an opportunity to cure. If the situation is ongoing and continuous and remains uncured after a set period of time, then, it gets passed on to the next step, going to the board for imposition of a fine. We covered the noticing procedure. We want to make sure that the notice gives a description of the violation. Again, that goes towards this requirement that we satisfy due process. The owner knows what's going on, what did they do wrong, how do they fix it. A reasonable amount of time for the correction. If you have a picture of the violation, that's the picture speaks 1,000 words, right? Let's just put the picture in with the notice, and that certainly provides better evidence down the road if we get in front of a fining committee. All right. If the violation has not been corrected within the required time frame, we notify the owner via certified mail. Violation still exists, and either if your process allows us for a second notice before it goes to the board and then the fining committee, that's fine. Other communities, or depending on the violation, it's a one-time notice and then we send it to the board. That's fine too. You may want to send out a final notice before we implement, imposing a fine by the board, and that's fine too. We should indicate how much the fine is going to be as part of the warning, if we can or if we know. We talked about the 14 days notice that must be given before a fining committee hearing can be held. That should be, the board meeting has got to be noticed 48 hours in advance. You should also notice your fining committee meeting if you're a condo or a co-op. Again, same 48-hour notice requirement. Yep.
So that brings up a good question. So is there any situations like with recurring fines, such as like garbage cans or trucks, where they can immediately issue a fine since it's been habitual, and or like unapproved renovation work, etc.?
Yeah. So where you have a situation where the person keeps engaging in the same type of violation, you can work that into your fining process. What you could conceivably do is, bypass the notices that you would typically send to somebody prior to the board levying the fine. We can't bypass the fining, the board imposing the fine at a board meeting or through some type of policy that's been approved by the board. And we cannot bypass a fining committee meeting. But you might be able to bypass those initial notices that go out at the front end, because this person's already been told before, especially if, you have a situation where whatever they've done has gone through the entire process, they've been fined, and then within a certain period, they're doing it again. Okay. So that can all be spelled out in a enforcement and fining policy. When we talk about somebody who's making interior renovations without board approval, to me, that's an ongoing situation, and that may be appropriate for the fining process as well as immediately contacting legal counsel, because you may need to seek, emergency temporary injunction from a court to stop the renovation process, particularly in a condominium or co-op building. before the work gets along too far. So that when you have a scenario like that, I would immediately reach out to council, because that may fall into the category of, okay, we'll run the fining course, but that's just one of more than one remedy we need to pursue, because of how serious the conduct is. All right, we talked about the board meetings and voting on the fine, and then sending out the actual letter for the committee meeting. Right. So when we talk about the suspension process, let's talk about when that can occur, and how to go about the suspension process. So when we're talking about suspending use rights, that's similar to levying a fine, but there's other scenarios where you have the right under 718, 719, and 720 to suspend a person's rights when they haven't paid assessments or other monetary obligations, such as the fines, to the association. Okay, so for any monetary obligation greater than 90, that's past due for more than 90 days, for condos and HOAs, the board can suspend use rights and voting rights. Okay, that has to be done at a board meeting. So if we're going to suspend somebody's use rights and voting rights, you can do both. You can do one or the other. Typically, it makes sense to do both if you're going to go through the process. And if we're suspending use rights and voting rights because somebody has not paid a monetary obligation for more than 90 days, we don't have to go to the fining committee for that. That's simply a board process. And then once the board has voted on that at a duly noticed meeting, we then have to send written notice to the owner by mail. I recommend certified mail, that action has been taken. Prior to taking that action, I recommend giving the owner a warning that action is going to be taken if they don't handle paying their outstanding obligation. Okay. If we're suspending, and I want to make this clear, different from what we just talked about, if we're suspending somebody's use rights because they've committed some rule violation, then we follow the process we've been talking about throughout the seminar. If we're talking about now we have a situation, for example, where the fine's been on, you levied the fine, it hasn't been paid, and you want to go the additional step of suspending somebody's voting rights, then you're talking about simply the board action and that 90-day period going past first. Also, as an aside, the statutes were amended. If somebody hasn't paid their assessments, not fines, but only assessments, that can render them ineligible to run for the board. So that's just a side note there. If the committee approves, by a majority vote, again, we need to, whether it's a fine or suspension, we need to send notice of the committee action to the owner, whether the owner was there or not. So even if the owner shows up, the committee may or may not make that decision in front of the owner. They may take the situation under advisement, and then after the owner has excused himself or herself from the meeting, the board may then, the committee, may then vote. And so we need to send notice of what the committee's action was to the owner. And I would suggest doing so whether it was approved or disapproved. So if it was disapproved, I think the owner is entitled to be notified of that. If it was approved, we need to send out notice of the approval of the fine or suspension. And we must give them at least 5 days notice before that monetary fine is considered due and payable to the association. The statute says 5 days. I think it's been clarified to say 5 days from when mailed, not from when the committee makes the decision. Certainly, I think it should run from when the letter goes out, not from when the committee made the decision. Okay. Briefly, let's talk about the HOA suspension process. Similar to similar to what we talked about before. One of the things you cannot do is deny a person access to their unit or property. So if we're talking about suspension of rights, we always have to make sure that the owner has the ability to get to and from their property, whether we're talking about a condominium, co-op, or homeowners association lot. Okay. So what rights can we suspend other than access or utilities? Utilities cannot be suspended. Can't shut off somebody's electricity or water. The question that always comes up is, can I shut off the person's cable? Statute doesn't prohibit that. That really is a provider question. Some providers won't do that, and some will. So it really depends. The other thing you want to be careful of is if it's internet, you may want to be careful about shutting off somebody's internet access, because that may have some safety ramifications in their home. Okay. So areas we can suspend are, the common elements, other common facilities such as pool, clubhouse, recreational facilities, exercise room, those types of things. All right. Again, we've got to follow the same process that we followed before with fines for suspensions. So I'm not going to belabor these points. And the committee has to approve that process. Okay. Let's see what else we got here.
Steve, just going back to the process, there's quite a few questions. I'm going to just try to grab a few of them. On the actual notice, is it required that it be sent out certified mail?
So when we're sending out notice of the fining committee hearing, that needs to be sent out by certified mail. Whether you want to send out your initial notices of the violation by certified mail, that's up to the the particular association, because I realize these mail expenses start to add up. But one of the common things you'll hear at a fining committee hearing is, I didn't get the notice. Well, how are you going to, the manager's going to have to say, well, I mailed the notice on this date, and it was sent to this address, which was the address on file with the association. I always like to check the property appraiser website to see if there's a different mailing address on property appraiser than what we may have as an association in our records. And if I have two addresses for somebody, I send them to both addresses. In a condominium in the building where we know who's in residence, we're more likely to know who's in residence and who isn't. We have a better feel for where to direct the notice, but I always like to err on the side of caution and send it to whatever addresses I have. If I happen to have an email address on file, I would also send it by email. Get a delivery receipt on your, on your Outlook. But that's not going to be statutory compliance. You still have to send the notice of the fining committee hearing by certified mail. But I like to send things as many different ways as I can to make sure that I take the argument away from the owner that I didn't get notice of the violation. Okay.
Okay, well, with that, we are at 1:01, and I am going to make a major announcement that I will not allow any further 1-hour courses, CE or otherwise, and everybody has to add 30 minutes to their courses for all these extra questions. So with that said, I want to say thank you,
Sure.
Steve. Is there any closing things you'd like to say real quick before I close?
Well, Peggy, we have a lot of questions. Can we try to get to some of those, or?
Let me make a couple announcements, and for those who want to stay on, you may stay on for the questions, but we are also going to send you the questions that you can return back to everyone. Just real quick, let me announce I have an upcoming webinar you might want to mark your calendars for on March 23rd. It's called Active Shooter Response. This is very near and dear to all of our hearts here with all these wild shootings going on. Please be safe out there. The next webinar is March 29th. It's another board certification from 12 to 2 p.m. And with that, I want to say thank you, everyone. Please have a wonderful holiday season or holy season as we go on along. Back to Katie for how many questions you want to continue. I will stay on.
Yeah, we have some really good questions. I mean, obviously, if you need to leave, you're getting the credit for the class at this point, but there's some really good questions that I wanted to give. I can't get to everything, but I will definitely try to get some of these, because some of these are really good. So, Steve, can the board make resolutions for fines if they don't have anything in their governing documents to do the violations process?
Right. So the question is, if the governing documents don't address the fining process, can the board adopt a resolution. So the answer is yes. So the authority to implement the fining process comes from the statutes we talked about today, 718, 719, and 720. Implementing a resolution would be to like lay out the process for your community and how you're going to implement that process and what types of notices and warnings you're going to provide to owners before they get to the fining committee. And then just one thing I want to mention, and are we going to be providing the slide presentation to
Yes.
everybody? So everybody's going to get the slide presentation from today. And at the end of the presentation, I have at the end a summary, which I call the perfect fine, because I call it that because I'm laying out the whole process that you need to follow. And then if you follow that process, you should be okay. First thing we do when a client asks us to collect fines or lien a property for fines, if you're an HOA, is we're going to ask you for all the backup documentation to see that you followed the process from A to Z correctly. Because if you haven't, we're not going to move forward with liening a property for fines, because we as a law firm would have exposure for doing that, and the fine wasn't levied correctly per statute. And there's cases from the appellate courts directly on point that say if you didn't follow the process correctly, the fine is not valid. Somebody actually sued their association because the fine got put on their ledger. They didn't believe the fine was properly levied, and they took it all the way up to the appellate court to challenge that money being posted on their ledger.
Wow, awesome. So, Steve, one of your favorite topics is the code of conduct or ethics policy. Can that be enforceable with fines?
So the question is whether a code of conduct or ethics policy against that is usually governed that governs board members' conduct, can that be enforced by fines? I don't see why I couldn't. I mean, if the board makes a determination that a member of the board or a committee committed a violation of the code of conduct policy, that policy is just like any other rule and regulation.
Awesome. How about actually abatement instead of fines? So in other words, they don't cut their grass, and the association needs to do that to keep the aesthetics.
So the question is, if somebody's not maintaining their lawn, can the association engage in abatement in lieu of fines? And that would depend on the authority granted the association in the documents. So if you have the right to come in and cure a exterior defect, and this would typically be only in an HOA, the answer is yes, if that authority is in your documents. And usually there's a specific amount of time that you have to provide the owner notice of the violation before you can engage in that kind of self-help. If the owner is in residence, you may want to be careful there, because that could turn into an altercation if your landscapers show up on their property in their home. Now, if you've got an abandoned property, which is, not unusual, and the owner, you can't find the owner, you still send out the notice to the last address, and then you'll have less resistance certainly in doing that exterior landscaping. Don't recommend getting up on somebody's roof and pressure cleaning somebody's roof if the roof has not been cleaned, or painting somebody's house if they're refusing to paint their house. That might get interesting.
Awesome. Several questions about can the owners appeal the fine back to the board?
So can the owner appeal the fine back to the board? My position on that is no, because you've already run through a two-step process. So the board's levied the fine, the committee has now accepted the fine, and now the owner is not happy with that, and so they want to go back to the board. I think if you do that, it undermines the process. So it used to be understood that prior to the amendments that were done, I think in around 2015, that fines would go directly to a fining committee, and then you'd come to the board if the committee levied the fine. Since the board has already taken action in the first place, I don't think you come full circle. I think that would undermine the process.
Awesome. We have,
and those are my thoughts. Another attorney may have a different opinion. If you have an express appellate provision in your documents, the answer may be different, but based on the statute, that would not normally be the flow, so to speak.
So tenants, can you find the tenants?
Yes, the tenant is governed by the statute and your rules and regulations, and you can fine a tenant. The question then becomes collectability. To me, it's more effective to fine the owner for the tenant's conduct. And then if the fine doesn't get paid, send a letter to the tenant requesting them to pay the rent to the association to satisfy the fining obligation that's outstanding. That's probably a more effective route to go. Also, if the tenant is engaging in behavior that's warranting a fine, that could constitute a breach of the owner's lease with the tenant, and the owner may want to evict the tenant. So I like to focus on the owner. It's just cleaner that way.
Awesome. And I'll just do one more because there's so many, and I'm sorry if we didn't get to your questions. You can email me, my information's in the chat, and I'll be sending you a copy of the slides. But Steve's favorite question, what happens if we can't get anybody to serve on the fines committee?
If we can't get anybody to serve on the fines committee, then we cannot engage in fining or suspensions. And your only recourse at that point is turning to your association counsel to send a follow-up violation letter or cease and desist letter and use the legal process, because in the absence of a committee, we can't levy a valid fine or suspension.
Thank you all again. Thank you, Peggy, for having us. And
Yes.
again, if I didn't get to you, I'm sorry, but you feel free to email us.
And thank you, everybody, for attending today. We had a great turnout. Thank you so much.
Okay, thank you. Thanks, Leila.
Thanks, everyone.
now.
Bye.
Bye.
Bye.